In this video, we are going to talk about America legal system. So before starting this video, please like this video, and subscribe to this channel for our future updates. Law of the United States. The law of the United States comprises many levels of codified and uncodified forms of law, of which the most important is the United States Constitution, which prescribes the foundation of the federal government of the United States, as well as various civil liberties. The Constitution sets out the boundaries of federal law, which consists of acts of Congress, treaties ratified by the Senate, regulations promulgated by the executive branch, and case law originating from the federal judiciary. The United States Code is the official compilation and codification of general and permanent federal statutory law. Federal law and treaties, so long as they are in accordance with the Constitution, preempt conflicting state and territorial laws in the 50 U.S. states and in the territories. However, the scope of federal preemption is limited, because the scope of federal power is not universal. In the dual sovereign system of American federalism, actually tripartite because of the presence of Indian reservations, states are the plenary sovereigns, each with their own constitution, while the federal sovereign possesses only the limited, supreme authority enumerated in the Constitution. Indeed, states may grant their citizens broader rights than the federal Constitution, as long as they do not infringe on any federal constitutional rights. Thus, most U.S. law, especially the actual, living law, of contract, tort, property, criminal, and family law experienced by the majority of citizens on a day-to-day basis, consists primarily of state law, which can and does vary greatly from one state to the next. At both the federal and state levels, with the exception of the state of Louisiana, the law of the United States is largely derived from the common law system of English law, which was in force at the time of the American Revolutionary War. However, American law has diverged greatly from its English ancestor both in terms of substance and procedure and has incorporated a number of civil law innovations. Sources of law in the United States. The law is derived from 5 sources: constitutional law, statutory law, treaties, administrative regulations, and the common law, which includes case law. Constitutionality. Where Congress enacts a statute that conflicts with the Constitution, state or federal courts may rule that law to be unconstitutional and declare it invalid. Notably, a statute does not automatically disappear merely because it has been found unconstitutional. It may, however, be deleted by a subsequent statute. Many federal and state statutes have remained on the books for decades, after they were ruled to be unconstitutional. However, under the principle of stare decisis, no sensible lower court will enforce an unconstitutional statute, and any court that does so will be reversed by the Supreme Court. Conversely, any court that refuses to enforce a constitutional statute, where such constitutionality has been expressly established in prior cases, will risk reversal by the Supreme Court. American common law. The United States and most Commonwealth countries are heirs to the common law legal tradition of English law. Certain practices traditionally allowed under English common law were expressly outlawed by the Constitution, such as bills of attainder and general search warrants. As common law courts, U.S. courts have inherited the principle of stare decisis. American judges, like common law judges elsewhere, not only apply the law, they also make the law, to the extent that their decisions in the cases before them become precedent for decisions in future cases. The actual substance of English law was formally received into the United States in several ways. First, all U.S. states, except Louisiana, have enacted reception statutes, which generally state that the common law of England, particularly judge-made law, is the law of the state to the extent that it is not repugnant to domestic law or indigenous conditions. Some reception statutes impose a specific cutoff date for reception, such as the date of a colony's founding, while others are deliberately vague. Thus, contemporary U.S. courts often cite pre-revolution cases when discussing the evolution of an ancient judge-made common law principle into its modern form, such as the heightened duty of care traditionally imposed upon common carriers. Second, a small number of important British statutes in effect at the time of the Revolution have been independently reenacted by U.S. states. Two examples are the Statute of Frauds, still widely known in the U.S. by that name, and the Statute of 13 Elizabeth, the ancestor of the Uniform Fraudulent Transfer Act. Such English statutes are still regularly cited in contemporary, American cases interpreting their modern American descendants. Despite the presence of reception statutes, much of contemporary American common law has diverged significantly from English common law. Although the courts of the various Commonwealth nations are often influenced by each other's rulings, American courts rarely follow post-Revolution precedents from England or the British Commonwealth. Early on, American courts, even after the Revolution, often did cite contemporary English cases, because appellate decisions from many American courts were not regularly reported until the mid-19th century. Lawyers and judges used English legal materials to fill the gap. Citations to English decisions gradually disappeared during the 19th century, as American courts developed their own principles to resolve the legal problems of the American people. The number of published volumes of American reports soared from 18 in 1810 to over 8,000 by 1910. By 1879, one of the delegates to the California Constitutional Convention was already complaining, "Now, when we require them to state the reasons for a decision, we do not mean they shall write 100 pages of detail. We do not mean that they shall include the small cases, and impose on the country all this fine judicial literature, for the Lord knows we have got enough of that already." Today, in the words of Stanford law professor Lawrence Friedman, American cases rarely cite foreign materials. Courts occasionally cite a British classic or two, a famous old case, or a nod to Blackstone, but current British law almost never gets any mention. Foreign law has never been cited as binding precedent, but as a reflection of the shared values of Anglo-American civilization, or even Western civilization in general. Levels of law. Federal law. Federal law originates with the Constitution, which gives Congress the power to enact statutes for certain limited purposes, like regulating interstate commerce. The United States Code is the official compilation and codification of the general and permanent federal statutes. Many statutes give executive branch agencies the power to create regulations, which are published in the Federal Register and codified into the Code of Federal Regulations. Regulations generally also carry the force of law under the Chevron doctrine. Many lawsuits turn on the meaning of a federal statute or regulation, and judicial interpretations of such meaning carry legal force under the principle of stare decisis. During the 18th and 19th centuries, federal law traditionally focused on areas where there was an express grant of power to the federal government in the federal constitution, like the military, money, foreign relations, especially international treaties, tariffs, intellectual property, specifically patents and copyrights, and mail. Since the start of the 20th century, broad interpretations of the Commerce and Spending Clauses of the Constitution have enabled federal law to expand into areas like aviation, telecommunications, railroads, pharmaceuticals, antitrust, and trademarks. In some areas, like aviation and railroads, the federal government has developed a comprehensive scheme that preempts virtually all state law, while in others, like family law, a relatively small number of federal statutes, generally covering interstate and international situations, interacts with a much larger body of state law. In areas like antitrust, trademark, and employment law, there are powerful laws at both the federal and state levels that coexist with each other. In a handful of areas like insurance, Congress has enacted laws expressly, refusing to regulate them, as long as the states have laws regulating them, see, e.g., the McCarran-Ferguson Act. Further information: United States statutes at large and list of United States federal legislation. The United States Code, the codification of federal statutory law. After the President signs a bill into law, or Congress enacts it over his veto, it is delivered to the Office of the Federal Register (OFR) of the National Archives and Records Administration (NARA), where it is assigned a law number, and prepared for publication as a slip law. Public laws, but not private laws, are also given legal statutory citation by the OFR. At the end of each session of Congress, the slip laws are compiled into bound volumes called the United States Statutes at Large, and they are known as session laws. The statutes at large present a chronological arrangement of the laws in the exact order that they have been enacted. Public laws are incorporated into the United States Code, which is a codification of all general and permanent laws of the United States. The main edition is published every 6 years by the Office of the Law Revision Council of the House of Representatives, and cumulative supplements are published annually. The U.S. Code is arranged by subject matter, and it shows the present status of laws, with amendments already incorporated in the text that have been amended on one or more occasions. Congress often enacts statutes that grant broad rulemaking authority to federal agencies. Often, Congress is simply too gridlocked to draft detailed statutes that explain how the agency should react to every possible situation, or Congress believes the agency's technical specialists are best equipped to deal with particular fact situations as they arise. Therefore, federal agencies are authorized to promulgate regulations. Under the principle of Chevron deference, regulations normally carry the force of law, as long as they are based on a reasonable interpretation of the relevant statutes. Regulations are adopted pursuant to the Administrative Procedure Act (APA). Regulations are first proposed and published in the Federal Register (FR or Fed Reg), and subject to a public comment period. Eventually, after a period for public comment and revisions based on comments received, a final version is published in the Federal Register. The regulations are codified and incorporated into the Code of Federal Regulations (CFR), which is published once a year on a rolling schedule. Besides regulations formally promulgated under the APA, federal agencies also frequently promulgate an enormous amount of forms, manuals, policy statements, letters, and rulings. These documents may be considered by a court as persuasive authority as to how a particular statute or regulation may be interpreted, known as Skidmore deference, but are not entitled to Chevron deference. The United States Reports, the official reporter of the Supreme Court of the United States. Unlike the situation with the states, there is no plenary reception statute at the federal level that continued the common law, and thereby granted federal courts the power to formulate legal precedent, like their English predecessors. Federal courts are solely creatures of the federal Constitution and the federal judiciary acts. However, it is universally accepted that the Founding Fathers of the United States, by vesting judicial power into the Supreme Court and the inferior federal courts in Article 3 of the United States Constitution, thereby vested in them the implied judicial power of common law courts to formulate persuasive precedent. This power was widely accepted, understood, and recognized by the Founding Fathers at the time the Constitution was ratified. Several legal scholars have argued that the federal judicial power to decide cases or controversies necessarily includes the power to decide the precedential effect of those cases and controversies. The difficult question is whether federal judicial power extends to formulating binding precedent through strict adherence to the rule of stare decisis. This is where the act of deciding a case becomes a limited form of lawmaking in itself, in that an appellate court's rulings will thereby bind itself, and lower courts in future cases, and therefore also impliedly, binds all persons within the court's jurisdiction. Prior to a major change to federal court rules in 2007, about 1/5 of federal appellate cases were published, and thereby became binding precedents, while the rest were unpublished, and bound only the parties to each case. As federal judge Alex Kaczynski has pointed out, binding precedent, as we know it today, simply did not exist at the time the Constitution was framed. Judicial decisions were not consistently, accurately, and faithfully reported on both sides of the Atlantic. Reporters often simply rewrote, or failed to publish decisions which they disliked, and the United Kingdom lacked a coherent court hierarchy prior to the end of the 19th century. Furthermore, English judges in the 18th century subscribed to now obsolete natural law theories of law, by which law was believed to have an existence independent of what individual judges said. Judges saw themselves as merely declaring the law which had always theoretically existed, and not as making the law. Therefore, a judge could reject another judge's opinion, as simply an incorrect statement of the law, in the way that scientists regularly reject each other's conclusions, as incorrect statements of the laws of science. In turn, according to Kaczynski's analysis, the contemporary rule of binding precedent became possible in the U.S. in the 19th century only after the creation of a clear court hierarchy under the Judiciary Acts and the beginning of regular verbatim publication of U.S. appellate decisions by West Publishing. The rule gradually developed, case by case, as an extension of the judiciary's public policy of effective judicial administration, that is, in order to efficiently exercise the judicial power. The rule of binding precedent is generally justified today, as a matter of public policy, first, as a matter of fundamental fairness, and second, because in the absence of case law, it would be completely unworkable for every minor issue in every legal case to be briefed, argued, and decided from first principles such as relevant statutes, constitutional provisions, and underlying public policies, which in turn would create hopeless inefficiency, instability, and unpredictability, and thereby undermine the rule of law. The contemporary form of the rule is descended from Justice Louis Brandeis's landmark dissent in 1932's Burnett v. Coronado Oil and Gas Co., which catalogued the court's actual overruling practices in such a powerful manner that his attendant stare decisis analysis immediately assumed canonical authority. Here is a typical exposition of how public policy supports the rule of binding precedent in a 2008 majority opinion signed by Associate Justice Stephen Breyer. Justice Brandeis once observed that, in most matters it is more important that the applicable rule of law be settled than that it be settled right. Burnett v. Coronado Oil and Gas Co. To overturn a decision settling one such matter simply because we might believe that decision is no longer right, would inevitably reflect a willingness to reconsider others. And that willingness could itself threaten to substitute disruption, confusion, and uncertainty for necessary legal stability. We have not found here any factors that might overcome these considerations. It is now sometimes possible, over time, for a line of precedents to drift from the express language of any underlying statutory or constitutional texts until the court's decisions establish doctrines that were not considered by the text's drafters. This trend has been strongly evident in federal substantive due process and Commerce Clause decisions. Originalists and political conservatives, such as Associate Justice Antonin Scalia, have criticized this trend as anti-democratic. Under the doctrine of Erie Railroad Co. v. Tompkins 1938, there is no general federal common law. Although federal courts can create federal common law in the form of case law, such law must be linked one way or another to the interpretation of a particular federal constitutional provision, statute, or regulation, which in turn was enacted as part of the Constitution or after. Federal courts lack the plenary power possessed by state courts to simply make up law, which the latter are able to do in the absence of constitutional or statutory provisions replacing the common law. Only in a few narrow limited areas, like maritime law, has the Constitution expressly authorized the continuation of English common law at the federal level, meaning that in those areas federal courts can continue to make law, as they see fit, subject to the limitations of stare decisis. The other major implication of the Erie Doctrine is that federal courts cannot dictate the content of state law, when there is no federal issue and thus no federal supremacy issue in a case. When hearing claims under state law pursuant to diversity jurisdiction, federal trial courts must apply the statutory and decisional law of the state in which they sit, as if they were a court of that state, even if they believe that the relevant state law is irrational or just bad public policy. Under Erie, such federal deference to state law applies only in one direction: state courts are not bound by federal interpretations of state law. Similarly, state courts are also not bound by most federal interpretations of federal law. In the vast majority of state courts, interpretations of federal law from federal courts of appeals and district courts can be cited as persuasive authority, but state courts are not bound by those interpretations. The U.S. Supreme Court has never squarely addressed the issue, but has signaled in dicta that it sides with this rule. Therefore, in those states, there is only one federal court that binds all state courts, as to the interpretation of federal law and the federal Constitution, the U.S. Supreme Court itself. Volumes of the Thomson West annotated version of the California Penal Code, the codification of criminal law in the state of California. State law, United States. The 50 American states are separate sovereigns, with their own state constitutions, state governments, and state courts. All states have a legislative branch which enacts state statutes, an executive branch, that promulgates state regulations pursuant to statutory authorization, and a judicial branch that applies, interprets, and occasionally overturns both state statutes and regulations, as well as local ordinances. They retain plenary power to make laws covering anything not preempted by the federal Constitution, federal statutes, or international treaties ratified by the federal Senate. Normally, state supreme courts are the final interpreters of state constitutions, and state law, unless their interpretation itself presents a federal issue, in which case a decision may be appealed to the U.S. Supreme Court by way of a petition for writ of certiorari. State laws have dramatically diverged in the centuries, since independence, to the extent that the United States cannot be regarded as one legal system as to the majority of types of law traditionally under state control, but must be regarded as 50 separate systems of tort law, family law, property law, contract law, criminal law, and so on. Most cases are litigated in state courts and involve claims and defenses under state laws. In a 2012 report, the National Center for State Courts Court Statistics Project found that state trial courts received 103.5 million newly filed cases in 2010, which consisted of 56.3 million traffic cases, 20.4 million criminal cases, 19.0 million civil cases, 5.9 million domestic relations cases, and 1.9 million juvenile cases. In 2010, state appellate courts received 272,795 new cases. By way of comparison, all federal district courts in 2016 together received only about 552 new civil cases, 79,787 new criminal cases, and 833,515 bankruptcy cases, while federal appellate courts received 53,649 new cases. Local law states have delegated lawmaking powers to thousands of agencies, townships, counties, cities, and special districts. And all the state constitutions, statutes and regulations, as well as all the ordinances and regulations promulgated by local entities, are subject to judicial interpretation like their federal counterparts. It is common for residents of major U.S. metropolitan areas to live under 6 or more layers of special districts, as well as a town or city, and a county or township in addition to the federal and state governments. Thus, at any given time, the average American citizen is subject to the rules and regulations of several dozen different agencies at the federal, state, and local levels, depending upon one's current location and behavior. Legal subjects. American lawyers draw a fundamental distinction between procedural law, which controls the procedure followed by courts and parties to legal cases, and substantive law, the actual substance, or principles of law, which is what most people think of as law. Criminal law and procedure. Main articles: United States criminal law and United States criminal procedure. Criminal law involves the prosecution by the state of wrongful acts which are considered to be so serious that they are a breach of the sovereign's peace, and cannot be deterred or remedied by mere lawsuits between private parties. Generally, crimes can result in incarceration, but torts cannot. The majority of the crimes committed in the United States are prosecuted and punished at the state level. Federal criminal law focuses on areas specifically relevant to the federal government, like evading payment of federal income tax, mail theft, or physical attacks on federal officials, as well as interstate crimes like drug trafficking and wire fraud. All states have somewhat similar laws in regard to higher crimes, or felonies, such as murder and rape, although penalties for these crimes may vary from state to state. Capital punishment is permitted in some states but not others. Three strikes laws in certain states impose harsh penalties on repeat offenders. Some states distinguish between two levels: felonies and misdemeanors, minor crimes. Generally, most felony convictions result in lengthy prison sentences, as well as subsequent probation, large fines, and orders to pay restitution directly to victims, while misdemeanors may lead to a year or less in jail and a substantial fine. To simplify the prosecution of traffic violations, and other relatively minor crimes, some states have added a third level, infractions. These may result in fines and sometimes the loss of one's driver's license, but no jail time. For public welfare offenses where the state is punishing merely risky as opposed to injurious behavior, there is significant diversity across the various states. For example, punishments for drunk driving varied greatly prior to 1990. State laws dealing with drug crimes still vary widely, with some states treating possession of small amounts of drugs as a misdemeanor offense or as a medical issue, and others categorizing the same offense as a serious felony. The law of criminal procedure in the United States consists of a massive overlay of federal constitutional case law interwoven with the federal and state statutes that actually provide the foundation for the creation and operation of law enforcement agencies and prison systems, as well as the proceedings in criminal trials. Due to the perennial inability of legislatures in the U.S. to enact statutes that would actually force law enforcement officers to respect the constitutional rights of criminal suspects and convicts, the federal judiciary gradually developed the exclusionary rule as a method to enforce such rights. In turn, the exclusionary rule spawned a family of judge-made remedies for the abuse of law enforcement powers, of which the most famous is the Miranda warning. The writ of habeas corpus is often used by suspects and convicts to challenge their detention, while the Civil Rights Act of 1871 and Bivens actions are used by suspects to recover tort damages for police brutality. The law of civil procedure governs process in all judicial proceedings involving lawsuits between private parties. Traditional common law pleading was replaced by code pleading in 24 states, after New York enacted the Field Code in 1850, and code pleading in turn was subsequently replaced again in most states by modern notice pleading during the 20th century. The Old English division between common law and equity courts was abolished in the federal courts by the adoption of the Federal Rules of Civil Procedure in 1938. It has also been independently abolished by legislative acts in nearly all states. The Delaware Court of Chancery is the most prominent of the small number of remaining equity courts. 35 states have adopted rules of civil procedure modeled after the FRCP, including rule numbers. However, in doing so, they had to make some modifications to account for the fact that state courts have broad general jurisdiction, while federal courts have relatively limited jurisdiction. New York, Illinois, and California are the most significant states that have not adopted the FRCP. Furthermore, all three states continue to maintain most of their civil procedure laws in the form of codified statutes enacted by the state legislature, as opposed to court rules promulgated by the state Supreme Court, on the ground that the latter are undemocratic. But certain key portions of their civil procedure laws have been modified by their legislatures to bring them closer to federal civil procedure. Generally, American civil procedure has several notable features, including extensive pretrial discovery, heavy reliance on live testimony obtained at deposition, or elicited in front of a jury, an aggressive pretrial law in motion practice designed to result in a pretrial disposition, that is, summary judgment or a settlement. U.S. courts pioneered the concept of the opt-out class action, by which the burden falls on class members to notify the court that they do not wish to be bound by the judgment, as opposed to opt-in class actions, where class members must join into the class. Another unique feature is the so-called American rule, under which parties generally bear their own attorney's fees as opposed to the English rule of loser pays, though American legislators and courts have carved out numerous exceptions. Contract law covers obligations established by agreement, express or implied, between private parties. Generally, contract law in transactions involving the sale of goods has become highly standardized nationwide, as a result of the widespread adoption of the Uniform Commercial Code. However, there is still significant diversity in the interpretation of other kinds of contracts, depending upon the extent to which a given state has codified its common law of contracts, or adopted portions of the Restatement Second of Contracts. Parties are permitted to agree to arbitrate disputes arising from their contracts. Under the Federal Arbitration Act, which has been interpreted to cover all contracts arising under federal or state law, arbitration clauses are generally enforceable, unless the party resisting arbitration can show unconscionability, or fraud or something else which undermines the entire contract. The Restatement Second of Torts, a highly influential restatement of United States tort law generally covers any civil action between private parties arising from wrongful acts which amount to a breach of general obligations imposed by law and not by contract. Tort law covers the entire imaginable spectrum of wrongs which humans can inflict upon each other, and of course, partially overlaps with wrongs also punishable by criminal law. Although the American Law Institute has attempted to standardize tort law through the development of several versions of the Restatement of Torts, many states have chosen to adopt only certain sections of the restatements and to reject others. Thus, because of its immense size and diversity, American tort law cannot be easily summarized. For example, a few jurisdictions allow actions for negligent infliction of emotional distress even in the absence of physical injury to the plaintiff, but most do not. For any particular tort, states differ on the causes of action, types and scope of remedies, statutes of limitations, and the amount of specificity with which one must plead the cause. With practically any aspect of tort law, there is a majority rule, adhered to by most states, and one or more minority rules. Notably, the most broadly influential innovation of 20th century American tort law was the rule of strict liability for defective products, which originated with judicial glosses on the law of warranty. In 1963, Roger J. Traynor of the Supreme Court of California threw away legal fictions, based on warranties and imposed strict liability for defective products, as a matter of public policy in the landmark case of Greenman v. Yuba Power Products. The American Law Institute subsequently adopted a slightly different version of the Greenman Rule in Section 402A of the Restatement Second of Torts, which was published in 1964 and was very influential throughout the United States. Outside the U.S., the rule was adopted by the European Economic Community, in the Product Liability Directive of July 1985, by Australia in July 1992, and by Japan in June 1994. By the 1990s, the avalanche of American cases resulting from Greenman and Section 402A had become so complicated that another restatement was needed, which occurred with the 1997 publication of the Restatement Third of Torts, Products Liability. Admission to the bar in the United States is the granting of permission by a particular court system to a lawyer to practice law in the jurisdiction and before those courts. Each U.S. state and similar jurisdiction, e.g. territories under federal control, has its own court system and sets its own rules for bar admission, which can lead to different admission standards among states. In most cases, a person is admitted, or called, to the bar of the highest court in the jurisdiction, and is thereby authorized to practice law in the jurisdiction. Federal courts, although often overlapping in admission standards with states, set their own requirements for practice in each of those courts. In the typical process, lawyers seeking admission are required to earn a Juris Doctor degree from a law school approved by the jurisdiction, pass an exam administered by the regulating authority of that jurisdiction, pass a professional responsibility examination, and undergo a character and fitness evaluation. However, there are exceptions to each of these requirements. A lawyer who is admitted in one state is not automatically allowed to practice in any other. Some states have reciprocal agreements that allow attorneys from other states to practice without sitting for another full bar exam. Such arrangements differ significantly among states and among federal courts. The use of the term bar to mean the whole body of lawyers, the legal profession, comes ultimately from English custom. In the early 16th century, a railing divided the hall in the Inns of Court, with students occupying the body of the hall and readers or benchers on the other side. Students who officially became lawyers were called to the bar, crossing the symbolic physical barrier and thus admitted to the bar. Later, this was popularly assumed to mean the wooden railing, marking off the area around the judge's seat in a courtroom, where prisoners stood for arraignment and where a barrister stood to plead. In modern courtrooms, a railing may still be in place to enclose the space which is occupied by legal counsel as well as the criminal defendants and civil litigants who have business pending before the court. History: the first bar exam in what is now the United States was instituted by Delaware Colony in 1763 as an oral examination before a judge. Many other American colonies soon followed suit. In the early United States, most states' requirements for admission to the bar included a period of study under a lawyer, or judge, a practice called reading the law, and a brief examination. Examinations were generally oral, and applicants were sometimes exempted from the examination, if they had clerked in a law office for a certain number of years. During the 19th century, admission requirements became lower in many states. Most states continued to require both a period of apprenticeship and some form of examination, but these periods became shorter and examinations were generally brief and casual. After 1870, law schools began to emerge across the United States as an alternative to apprenticeship. This rise was accompanied by the practice of diploma privilege, wherein graduates of law schools would receive automatic admission to the bar. Diploma privilege reached its peak between 1879 and 1921. In most states, diploma privilege only applied to those who had graduated law school in the state where they practiced. Examinations continued to exist during this period, as requirements for those ineligible for diploma privilege, and were often administered by committees of attorneys. Between 1890 and 1920, most states replaced oral examinations with written bar examinations. Written examinations became commonplace, as lawyers began to practice in states other than those where they were trained. In 1921, the American Bar Association formally expressed a preference for required, written bar examinations in place of diploma privilege for law school graduates. In subsequent decades, the prevalence of diploma privilege declined deeply. By 1948, only 13 law schools in 9 states retained diploma privilege. By 1980, only Mississippi, Montana, South Dakota, West Virginia, and Wisconsin honored diploma privilege. As of 2020, only Wisconsin allows JD graduates of accredited law schools to seek admission to the state bar without passing a bar examination. Admission requirements today: each state or U.S. jurisdiction has its own rules which are the ultimate authority concerning admission to its bar. Generally, admission to a bar requires that the candidate do the following: earn a Juris Doctor degree or read law, pass a professional responsibility examination, or equivalent requirement, pass a bar examination, except in cases where diploma privilege is allowed, undergo a character and fitness certification, formally apply for admission to a jurisdiction's authority responsible for licensing lawyers and pay required fees. Educational requirement: see also law school in the United States and reading law. Most jurisdictions require that candidates earn a Juris Doctor degree from an approved law school, usually meaning a school accredited by the American Bar Association (ABA). Exceptions include Alabama, California, Connecticut, Massachusetts, West Virginia, and Tennessee, which allow individuals to take the bar exam upon graduation from law schools approved by state bodies but not accredited by the ABA. The state of New York makes special provision for persons educated to degree level in common law from overseas, with most LLB degree holders being qualified to take the bar exam, and, upon passing, be admitted to the bar. In California, certain law schools, registered with the Committee of Bar Examiners of the State Bar of California (CBE), are authorized to grant Juris Doctor degrees, although they are not accredited by the ABA or CBE. Students at these schools must take and pass the first-year law students examination, commonly referred to as the baby bar, administered by the CBE, and may continue their studies to obtain their JD degree upon passage of this exam. A few jurisdictions: California, Maine, New York, Vermont, Virginia, Washington, and West Virginia allow applicants to study under a judge, or practicing attorney for an extended period of time rather than attending law school. This method is known as reading law, or reading the law. New York allows applicants who are reading the law, but only if they have at least 1 year of law school study. Maine allows students with 2 years of law school to serve an apprenticeship in lieu of completing their 3rd year. New Hampshire's only law school has an alternative licensing program that allows students who have completed certain curricula and a separate exam to bypass the regular bar examination. Until the late 19th century, reading the law was common and law schools were rare. For example, Abraham Lincoln did not attend law school, and did not even read with anyone else, stating in his autobiography that he studied with nobody. The American legal system is unusual in that it has no formal apprenticeship or clinical training requirements prior to admission to the bar, with a few exceptions. Delaware requires that candidates for admission to the bar serve 5 months in a clerkship with a lawyer in the state. Vermont had a similar requirement, but eliminated it in 2016. Washington requires, since 2005, that applicants must complete a minimum of 4 hours of approved pre-admission education. Some law schools have tried to rectify this lack of experience by requiring supervised public service requirements of all graduates. States that encourage law students to undergo clinical training, or perform public service in the form of pro bono representation may allow students to appear and practice in limited court settings under the supervision of an admitted attorney. Professional responsibility requirement in all jurisdictions except Puerto Rico and Wisconsin. Candidates must pass the Multi-State Professional Responsibility Examination, MPRE, which covers the professional responsibility rules governing lawyers. This test is not administered separately from bar examinations, and most candidates usually sit for the MPRE while still in law school, right after studying professional responsibility, a required course in all ABA-accredited law schools. Some states require that a candidate pass the MPRE before being allowed to sit for the bar exam. Connecticut and New Jersey waive the MPRE for candidates who have received a grade of C or better in a law school professional ethics class. Citation needed. In all jurisdictions except Wisconsin, candidates are required to pass a bar examination, usually administered by the State Bar Association, or under the authority of the Supreme Court of the particular state. Wisconsin is the only state that does not require the bar examination. Graduates of ABA-accredited law schools in the state may be admitted to the state bar through diploma privilege. State bar examinations are usually administered by the State Bar Association, or under the authority of the Supreme Court of the particular state. In 2011, the National Conference of Bar Examiners, NCBE, created the Uniform Bar Examination, UBE, which has since been adopted by 37 jurisdictions, out of a possible 56. The UBE consists of 3 parts: the Multi-State Bar Examination, MBE, a standardized test consisting of 200 multiple-choice questions; the Multi-State Essay Examination, ME, a uniform though not standardized test that examines a candidate's ability to analyze legal issues and communicate them effectively in writing; and the Multi-State Performance Test, MPT, a closed-universe test in which each candidate is required to perform a standard lawyering task, such as a memo or brief. Non-UBE jurisdictions usually also include a combination of multiple-choice questions, essay questions, and performance tests. Many jurisdictions use some NCBE-created components. For example, all jurisdictions except Louisiana and Puerto Rico use the MBE. Many states also use state-specific content is usually included in the examination, such as essays in Washington, Minnesota and Massachusetts. Some states, such as Florida, include both essays and multiple-choice questions in their state-specific sections. Virginia uses full essays and short answer questions in its state-specific section. Character and fitness requirement. Most states also require an applicant to demonstrate good moral character. Character committees look to an applicant's history to determine whether the person will be fit to practice law in the future. This history may include prior criminal arrests or convictions, academic honor code violations, prior bankruptcies, or evidence of financial irresponsibility, addictions or psychiatric disorders, sexual misconduct, prior civil lawsuits or driving history. In recent years, such investigations have increasingly focused on the extent of an applicant's financial debt, as increased student loans have prompted concern for whether a new lawyer will honor legal or financial obligations. For example, in early 2009, a person who had passed the New York bar and had over $400,000 in unpaid student loans was denied admission by the New York Supreme Court Appellate Division due to excessive indebtedness, despite being recommended for admission by the state's Character and Fitness Committee. He moved to void the denial, but the court upheld its original decision in November 2009, by which time his debt had accumulated to nearly $500,000. More recently, the Court of Appeals of Maryland rejected the application of a candidate who displayed a pattern of financial irresponsibility, applied for a car loan with false information, and failed to disclose a recent bankruptcy. When applying to take a state's bar examination, applicants are required to complete extensive questionnaires, seeking the disclosure of significant personal, financial and professional information. For example, in Virginia, each applicant must complete a 24-page questionnaire and may appear before a committee for an interview if the committee initially rejects their application. The same is true in the state of Maryland, and in many other jurisdictions, where the state's Supreme Court has the ultimate authority to determine whether an applicant will be admitted to the bar. In completing the bar application, and at all stages of this process, honesty is paramount. An applicant who fails to disclose material facts, no matter how embarrassing or problematic, will greatly jeopardize the applicant's chance of practicing law. Formal admission: once all prerequisites have been satisfied, an attorney must formally apply for admission. The mechanics of this final stage vary widely. For example, in California, the admittee simply takes an oath before any state judge or notary public, who then co-signs the admission form. Upon receiving the signed form, the State Bar of California adds the new admittee to a list of applicants recommended for admission to the bar, which is automatically ratified by the Supreme Court of California at its next regular weekly conference. Then everyone on the list is added to the official roll of attorneys. The State Bar also holds large-scale formal admission ceremonies in conjunction with the U.S. Court of Appeals for the Ninth Circuit and the federal district courts, usually in the same convention centers where new admittees took the bar examination, but these are optional. In other jurisdictions, such as the District of Columbia, new admittees must attend a special session of court in person to take the oath of admission in open court. They cannot take the oath before any available judge or notary public. A successful applicant is permitted to practice law after being sworn in as an officer of the court. In most states, that means they may begin filing pleadings and appearing as counsel of record in any trial or appellate court in the state. Upon admission, a new lawyer is issued a certificate of admission, usually from the state's highest court, and a membership card attesting to admission. 2 states are exceptions to the general rule of admission by the state's highest court. In New York, admission is granted by one of the state's 4 intermediate appellate courts corresponding generally to the department of residence of the applicant. Once admitted, however, the applicant can practice in any non-federal court in the state. In Georgia, each new attorney is admitted to practice by the Superior Court of any county, typically the county in which he or she resides or desires to practice. The new attorney, although licensed to practice in any local trial court in the state, must separately seek admission to the Georgia Court of Appeals as well as the Georgia Supreme Court. In most states, lawyers are also issued a unique bar identification number. In states like California, where unauthorized practice of law is a major problem, clarification needed: the state bar number must appear on all documents submitted by a lawyer. Tactical considerations regarding admission: in multiple states, most attorneys seek and obtain admission only to the bar of one state, and then rely upon pro hac vice admissions for the occasional out-of-state matter. However, many new attorneys do seek admission in multiple states, either by taking multiple bar exams or applying for reciprocity. This is common for those living and working in metro areas which sprawl into multiple states, such as Washington, D.C. and New York City. Attorneys based in predominantly rural states, or rural areas near state borders frequently seek admission in multiple states in order to enlarge their client base. Note that in states that allow reciprocity, admission on motion may have conditions that do not apply to those admitted by examination. For example, attorneys admitted on motion in Virginia are required to show evidence of the intent to practice full-time in Virginia, and are prohibited from maintaining an office in any other jurisdiction. Also, their licenses automatically expire when they no longer maintain an office in Virginia. Types of state bar associations. Admission to a state's bar is not necessarily the same as membership in that state's bar association. There are two kinds of state bar associations. Mandatory integrated bar. 32 states and the District of Columbia require membership in the state's bar association to practice law there. This arrangement is called having a mandatory, unified, or integrated bar. For example, the State Bar of Texas is an agency of the judiciary, and is under the administrative control of the Texas Supreme Court, and is composed of those persons licensed to practice law in Texas, required by law to join the state bar by registering with the clerk of the Texas Supreme Court. Each such person is voluntary and private bar associations. A voluntary bar association is a private organization of lawyers. Each may have social, educational, and lobbying functions, but does not regulate the practice of law or admit lawyers to practice or discipline lawyers. An example of this is the New York State Bar Association. There is a statewide voluntary bar association in each of the 18 states that have no mandatory or integrated bar association. There are also many voluntary bar associations organized by geographic area, e.g., Chicago Bar Association, interest group, or practice area, e.g., Federal Communications Bar Association, or ethnic or identity community, e.g., Hispanic National Bar Association. The American Bar Association (ABA) is a nationwide voluntary bar association with the largest membership in the United States. The National Bar Association was formed in 1925 to focus on the interests of African American lawyers, after they were denied membership by the ABA. Federal courts' admission to a state bar does not automatically entitle an individual to practice in federal courts, such as the United States District Courts or United States Court of Appeals. In general, an attorney is admitted to the bar of these federal courts upon payment of a fee and taking an oath of admission. An attorney must apply to each district separately. For instance, a Texas attorney who practices in federal courts throughout the state would have to be admitted separately to the Northern District of Texas, the Eastern District, the Southern District, and the Western District. To handle a federal appeal, the attorney would also be required to be admitted separately to the Fifth Circuit Court of Appeals for general appeals, and to the Federal Circuit for appeals that fall within that court's jurisdiction. As the bankruptcy courts are divisions of the district courts, admission to a particular district court usually includes automatic admission to the corresponding bankruptcy court. The bankruptcy courts require that attorneys attend training sessions on electronic filing before they may file motions. Some federal district courts have extra admission requirements. For instance, the Southern District of Texas requires attorneys seeking admission to attend a class on that district's practice and procedures. For some time, the Southern District of Florida administered an entrance exam, but that requirement was eliminated by court order in February 2012. The District of Rhode Island requires candidates to attend classes and to pass an examination. An attorney wishing to practice before the Supreme Court of the United States must apply to do so, must be admitted to the bar of the highest court of a state for 3 years, must be sponsored by 2 attorneys already admitted to the Supreme Court bar, must pay a fee and must take either a spoken or written oath. Various specialized courts with subject matter jurisdiction, including the United States Tax Court, have separate admission requirements. The tax court is unusual in that a non-attorney may be admitted to practice. However, the non-attorney must take and pass an examination administered by the court to be admitted, while attorneys are not required to take the exam. Most members of the tax court bar are attorneys. Admission to the Court of Appeals for the Federal Circuit is open to any attorney admitted to practice, and in good standing with the U.S. Supreme Court, any of the other federal courts of appeal, any federal district court, the highest court of any state, the Court of International Trade, the Court of Federal Claims, the Court of Appeals for Veterans Claims, or the District of Columbia Court of Appeals. An oath and fee are required. Some federal courts also have voluntary bar associations associated with them. For example, the Bar Association of the Fifth Federal Circuit, the Bar Association of the Third Federal Circuit, or the Association of the Bar of the United States Court of Appeals. For the Eighth Circuit, all serve attorneys admitted to practice before specific federal courts of appeals. District Court Reciprocity. United States District Court Reciprocity Map 56 districts, around 60% of all district courts, require an attorney to be admitted to practice in the state where the district court sits. The other 39 districts, around 40% of all district courts, extend admission to certain lawyers admitted in other states, although conditions vary from court to court. Only 13 districts extend admission to attorneys admitted to any U.S. state bar. This requirement is not necessarily consistent within a state. For example, in Ohio, the Southern District generally requires membership in the Ohio State Bar for full admission, while full admission to the Northern District is open to all attorneys in good standing with any U.S. jurisdiction. In the Northern District of Ohio, admitted attorneys need not maintain an office in the district, or associate with a local attorney, unless ordered to do so by the court. The District of Vermont requires membership in the Vermont State Bar, or membership in the bar of a federal district court in the First and Second Circuits. The District of Connecticut, within the Second Circuit, will admit any member of the Connecticut Bar, or of the bar of any United States District Court. Patent practice persons wishing to prosecute patent applications, i.e., represent clients in the process of obtaining a patent, must first pass the USPTO registration examination, frequently referred to as the patent bar. Detailed information about applying for the registration examination is available in the USPTO's General Requirements Bulletin. Although only registered patent attorneys or patent agents can prosecute patent applications in the USPTO, passing the patent bar is not necessary to advise clients on patent infringement, to litigate patent issues in court, or to prosecute trademark applications. A JD degree is not required to sit for the patent bar. Lawyers who pass the patent bar exam may refer to themselves as a patent attorney. Rules of legal ethics prohibit lawyers from using the title patent attorney unless they are admitted to practice before the USPTO. While patent lawyers have a relevant 4-year degree and many have graduate technical degrees, patent litigation attorneys do not have to be patent attorneys, although some are. On the other hand, non-lawyers who pass the patent bar are referred to as patent agents. Patent agents may not hold themselves out as licensed attorneys. Applicants must have U.S. citizenship, permanent residency, a green card, or a valid work visa for a patent-related job. An applicant on a work visa, upon passing the exam, is only given limited recognition. Perform work for the employer listed on the work visa. Only U.S. citizens can maintain their registration in the patent bar while they are working outside the United States. Additionally, the USPTO requires that applicants to the patent bar have earned a bachelor's degree. Applicants are categorized as having earned an accredited bachelor's degree in a recognized technical subject, Category A, having earned a bachelor's degree in another subject, with sufficient credits to qualify for the exam, Category B, or having practical engineering or scientific experience, Category C. Applicants in Category A must have an engineering or hard science degree in a field listed in the General Requirements Bulletin. Note that the degree field as shown on the diploma must be exactly as it appears on the list. For example, aerospace engineering does not qualify under Category A, while aeronautical engineering does. A computer science degree is accepted under Category A, as long as it is received from an accreditation board for engineering and technology (ABET) accredited or CSAB accredited program. Applicants in Category B must have earned a bachelor's degree, and must have sufficient credits in science and engineering courses to meet the USPTO's requirements. The number of credits depends on the specific discipline. The coursework must include a minimum of 8 credit hours of acceptable classes in either chemistry or physics. Each course being relied upon by the applicant for credit is evaluated by the USPTO's Office of Enrollment and Discipline for Suitability. See the General Requirements Bulletin for the details. Engineering and computer science majors whose degree programs do not meet Category A requirements, typically due to the named field of the degree, or, especially in computer science, lack of program accreditation, can apply under Category B. Applicants in Category C may present evidence of passing the Fundamentals of Engineering exam as proof of technical education. They must also have a bachelor's degree. Although the admission requirements allow applicants to substitute proof of technical experience for technical education, this is rarely done in practice. Military law service. As a member of a military services Judge Advocate General's Corps requires graduation from an ABA-accredited law school, a license to practice law in any state or territory of the United States, and training at the specialized law school of one of the 3 military services: the Judge Advocate General's Legal Center and School for the Army, the Naval Justice School for the Navy, Marine Corps, and Coast Guard, and the Air Force Judge Advocate General School for the Air Force. In a court-martial, the accused is always provided JAG Corps defense counsel at no expense to the accused, but is also entitled to retain private civilian counsel at his or her own expense. Civilian counsel must either be a member of both a federal bar and a state bar, or must be otherwise authorized to practice law by a recognized licensing authority and certified by the military judge as having sufficient familiarity with criminal law as applicable in courts martial. If you enjoy this video and want to hear from me again, be sure to hit the subscribe button before you go. Thanks for watching.